You too. It's Tone. I'm back with another one for you. This one is going to be a compilation of a bunch of different case law. I found this PDF online. Look, everything all these videos that I do, this shit, you can find all this shit online, all right? You don't gotta buy any of this. You don't even really gotta search far and wide. I mean, there's websites out there. You can grab all this shit. So anyway, we're gonna go over this case law right here. And for anybody that knows, or even if you don't know, this is referred to as common law, right? So if you ever have a statement that you're trying to make and you need something to back it up, something that the that the courts pretty much have to honor, right? Because if there's ever been a ruling made on a particular situation by a judge, and most of these are like Supreme Court rulings and stuff like that, then the lower courts and other judges usually go along with whatever the rulings that were made on any particular topic. We're going to go over a few different topics here. And if any of these pertain to maybe a case that you're going through or whatever, and you have a point that you want to be made and something that's going to be valid and something that you can stand on, something that's already been heard in a different court and has already been made a ruling on. And so you can just, go speed past all the nonsense and just be like, hey, look, this is what I'm going to go with this case here. That is common law. All right. So now here we're gonna go over a bunch of different things that go over the power that the government does and doesn't have, some of their limited delegated authorities that they've been given the privilege to have, and they've been fucking trampling all over these things. You know what I mean? So let's go ahead and get into this. So right here we got uh this is Kokonin versus Guardian Life. So right here it says the federal courts are courts of a limited jurisdiction. They only possess the power authorized by the Constitution and statute, which is not to be expanded by judicial decree. Meaning that the courts don't have the authority to try to bend whatever the words mean. It's pretty much right there in black and white. You know what I mean? So they don't really have the authority to create laws out of rulings and case law, which they actually do, right? And so, but since they do that, we're going to use that to our advantage by using these rulings that they use to essentially make law out of different codes and statutes and their understanding of them. And so we just go ahead and take those and use them to our benefit. So right here, Kansas versus Colorado. The government of the United States is one of enumerated powers that has no inherent powers of sovereignty, right? Meaning that the United States government does not have any inherent powers of sovereignty, right? And they can't have more than the people who gave them the authority in the first place, which is us, the people of this land, the sovereign, right? We're the ones that delegated them a little bit of authority, and they can never have more authority than the people who gave that to them, which would be us. Okay. So that the enumeration of the powers granted is to be found in the Constitution of the United States, and in that alone, that the manifest purpose of the 10th Amendment to the Constitution is put to beyond dispute the proposition that all powers not granted are reserved to the people, and that if the changes of the years further powers ought to be possessed by Congress, they must be obtained by a new grant from the people. All right, so this basically says that all of the authority that was given to them by us initially uh, is all of the power that they can have. And if anything else that they need more power for is going to have to be granted from us in a in like a separate document that we all have to sign individually. Okay. So here we got Will versus Michigan State Department of State Police. So states are protected by the 11th Amendment while municipalities are not. Municipalities are not protected by the 11th Amendment. So, number one, the Supreme Court agreed that the state itself is not a person under 1983, but held that a state official acting in his or her official capacity also is not such a person. Okay, interesting. So, number two, specifically, the court invokes the following interpretive principles. The word persons with an S is ordinarily construed to exclude the sovereign. Congressional intent to affect the federal state balance must be clear and manifest. And intent to abrogate states' 11th Amendment immunity must appear in the language of the statute itself. So here we got Valley versus Northern Fire and Marines Insurance Company. Reached a wrong conclusion. The judgment is not void. It is merely error to be corrected on appeal or by motion to vacate, timely made. But as long as it stands, it is binding on everyone. That basically says that when you agree to by being silent, so silence being acquiescence, if you agree to a ruling, even though it was a wrong ruling, the judgment is not void. It is a error to be corrected on appeal or by motion to vacate. Once you realize the error has been made, and you go ahead and file that to a appellate court, and it must be made timely as well. I'm not sure what the time frame on that is, but I think it's a couple years. Might be like 3 years or so. So Old Main Mutual Life Insurance versus McDonald. The validity of a judgment may be attacked collaterally by evidence showing that the court had no jurisdiction. It is not perceived how any allegation contained in the record itself, however strongly made, can affect the right so to question it. The very objective of evidence is to invalidate the paper as a record. If that can be successfully done, no statements contained therein have any force. If any such statement could be used to prevent inquiry, a slight form of words must always be adopted so as effectually to nullify the right of such inquiry. Recitals of this kind must be regarded as asseverations of good faith in a deed which avail nothing and the instrument is shown to be fraudulent. So basically what that's saying is that if a if a case was created based on false evidence and you can prove that that paper and or affidavit in and of itself was faulty or was not valid in any way, then the whole case has to be thrown out essentially because you can't build a case on a faulty foundation or a building or whatever you want to call it. So here we got Louisville Joint Stock Land Bank versus Radford, the bankruptcy power. And so if you need this document here with any of these case laws to help you with any cases that you're in to help you beat them, just let me know. I'll send it to you in an email for free. The bankruptcy power, like the other great substantive powers of Congress, is subject to the Fifth Amendment. First sentence and syllabus. Number one, the Fifth Amendment commands that however great the nation's need, private property shall not be taken, even for a wholly public use without just compensation. And this is all written in your state constitutions as well, in your Bill of Rights. You know what I mean? This goes along with people who have had their car towed and shit like that. You know, they can't just go tow your car without what do you call it? Without just compensation. And there's a process that has to be taken there as well. So number two, to take valuable rights in specific property from one person and give them to another in violation of the Constitution. And you do have a Bill of Rights in all your state. And so whenever you go to court, right, you don't want to go there arguing about the U.S. Constitution. You're not a party to that shit. The U.S. Constitution is what these dickheads sign up to uphold and they never do. But that's not an argument for you to bring up. You always want to go there with your state constitution, which is your Bill of Rights, and you just want to go ahead and bark those off at them and maybe have a read along in case they forgot what the fuck that was. All right. So right here, when the revolution took place, the people of each state became themselves sovereign. And we've always been sovereign. And I don't know why that's a funny word for anybody to fucking hear and then to talk shit about. Anybody who has a fucking problem with somebody calling themselves sovereign is probably a fucking pussy ass slave. All right. So why would you even sit there and argue with a fucking moron like that? If they don't want to be sovereign, then fucking let them go fucking listen to somebody else and do whatever the fuck they're told, like the bitches that they are. But if you're sovereign and you say that and somebody has an issue with that, I promise you it's because they're a fucking slave ass moron, bro. And just let them be them. Let them be them. So Chisholm versus Georgia. When sovereigns are sued in their own court, such a method may have been established as the most respectful form of demand, but we are not now in a state court. And if sovereignty be an exemption from suit in any other than the sovereign's own courts, it follows when a state by adopting the Constitution, has agreed to be amendable to the judicial powers of the United States. She has, in that respect, given up her sovereignty. So, what that's saying essentially is that everybody's sovereign until they enter into a contract, such as the Constitution, allowing themselves to be bound by a particular rule or law or code or statute and things along those lines. So, when you agree to be bound by those particular rules there, then essentially you give up your sovereignty for that particular benefit or privilege, right? So number 9, the right of an American citizen to criticize public officials and policies is the central meaning of the Fifth Amendment. And so this case law here to support that as well, basically saying that you do have the right to question these motherfuckers whenever the fuck you feel like it. And that's whenever you feel like it. Because keep in mind that these people are all public servants. And they somehow have convinced these people wearing costumes that they're the boss of everybody who's wearing regular clothes. Now, I mean, unless they like wearing those fucking weird ass costumes that you always see them in with them fucked up giant hats. I don't know if that's a fashion statement or not, but I don't think that they're wearing those things by choice. I think that they were fucking broke and looking for a job and decided to become a servant and started taking orders from somebody else who don't even work for the fucking people and just started violating everybody's rights and shit without even realizing that they're the ones that are ultimately going to be liable for that shit. It doesn't matter which one of your bosses told you to go do that fuck shit. You're the one that's going to have to deal with the consequences of that, not your boss. All right? And keep in mind that all of these people are servants because, like I said, they're not wearing those costumes for nothing, not because they look good and not because they're comfortable. They're broke ass morons who decided to be fucking servants and somehow got fucking convinced that they're not when they wear a badge that says it. So, like, this is the world that we live in. It's crazy, twisted, and unconstitutional. It's fucking stupid. An unconstitutional act is not law. It confers no rights, it imposes no duties, affords no protection, it creates no office, it is in legal contemplation as an inoperative, as though it had never been passed. All right. So this basically is saying that any code or statute that is the opposite of what the Constitution is essentially null and void on its face. And you can just approach that particular code of statute as if it had never even got written in the first place. All right. So this is codes and statutes that allow you to go ahead and file that into the record as to the reason why you chose to ignore the unconstitutional code or statute. All right. So you have these to back it up. When they ask you, oh, so why do you think you can just do this? You think because you're a sovereign, you can do whatever you want? Actually, yeah, bro. And why? Because and then you just file this case law. Why do I think I can just do whatever I want regardless of what you say? It's because this shit has already been ruled on in a fucking case, and it says that if I find a code of statute that is opposed to the Constitution, then I can just go ahead and act as if it had never been passed. That's why I'm doing that. So there it is. All right. So all subjects over which the sovereign power of the state extends are objects of taxation, but those over which it does not extend are exempt from taxation. This proposition may almost be pronounced as self-evident. The sovereignty of the state extends to everything which it exists by its authority or permission. All right, so let me go ahead and write this down. All right. So a state cannot exclude a person from the practice of law or from any other occupation in a manner or of reasons that contravene the due process of equal protection as per the Supreme Court in this ruling here, Schwartz versus the Board of Examiners. So 13, when it clearly appears that the court lacks jurisdiction, the court has no authority to reach the merits. In such a situation, the action should be dismissed for want of jurisdiction. So there it is, too. If you can show that the court does not have any jurisdiction, you can go ahead and file these cases. 14, the privileges and immunities of citizens of the United States do not necessarily include all the rights protected by the first 8 amendments of the federal Constitution against the powers of the federal government. However, late this objection has been made or may be made in any cause in an inferior or appellate court of the United States. It must be considered and decided before any court can move one further step in the clause. So this basically is saying that if you find that these people don't have any jurisdiction or whatever, uh, that it has to be brought to the court's attention, and they're not able to move forward at all until that issue has been rectified or that question has been answered. As any movement is necessarily the exercise of jurisdiction, and it's for that reason. So if you start to question their jurisdiction, they're not able to move forward at all until the matter of jurisdiction has been settled to your satisfaction at that. Not even just a fucking answer that they fucking decide to give you, or any answer that they try to give you to bounce around the fact and try not to answer you. Jurisdiction is the power to hear and determine the subject matter in controversy between parties to a suit, to adjudicate or exercise any judicial power over them. The question is whether on the case before a court, their action is judicial or extrajudicial, with or without the authority of law to render a judgment or decree upon the rights of the litigant parties. And I would go so far as to say that most of their rulings are extrajudicial, meaning that it's really out of their realm and out of their authority and jurisdiction most of the times. But because your silence is acquiescence, they go ahead and move forward as if you just agreed to it. So every litigant is entitled to nothing less than the cold neutrality of an impartial judge. Right. And when you start to look into these judges' private business dealings, you're going to see that a lot of the time there's a conflict of interest with a lot of their rulings. And that's an easy way to get all your cases tossed too as well when you start to fucking investigate these clowns. All right. You start to see that they have money in a lot of these businesses that they're throwing people in the jails and shit like that too. You know what I mean? A citizen of the United States is a citizen of the federal government. And I'm keep in mind, bro, that a citizen of the United States isn't even a real thing because the federal government isn't even a fucking real thing. Those things only exist on paper and they exist in your mind. That is it. It's not something you can put in your hand. You can never call the United States to the stand. You can never call the state of Massachusetts to the stand. You can never call the state of Texas to the stand because they don't exist. But they're going to sit there and act like somehow either of these corporations are ever a victim in any of these suits when you can never question them, which obviously violates your rights at that. You have the right to question your fucking accuser. Now, if I call the state of Massachusetts to the stand, who's going to come up and fucking answer for the state? Nobody, because it isn't even real. A person has been seized within the meaning of the Fourth Amendment only if, in view of all the circumstances surrounding the incident, a reasonable person uh, would have believed that he was not free to leave. And as long as the person to whom questions are put remains free to disregard the questions and walk away, there has been no intrusion upon that person's liberty or privacy as would require some particularized and objective justification. So and this is why you have to ask them if you're being detained or if you're free to go most of the time, right? And they'll probably just jump around all that shit and try not to answer you. But in all reality, if these people stop you and waste your time for any amount of any fucking day, they have already violated your fucking rights. Okay. And so you can start charging them accordingly. So when you have your fee schedule in place and you already put these people on notice, and so when they take their time and they start ruining your day by fucking bothering you and shit like that, when there's been no fucking crime committed, meaning that there's no victims involved, then you can start charging them accordingly just for fucking wasting your day and making you even have to think about them. Because really, who the fuck are they anyway? You know what I mean? So, in common usage, the term person does not include the sovereign, and statutes employing the phrase are ordinarily construed to exclude it. So what they're saying right there is anytime you see a code of statute making reference to the word person, they're usually making reference to it in a commercial commercial tense. So it's not making reference to you, the sovereign, at all. And to be honest with you, any of these codes and statutes, for them to be relevant and applicable to you personally, your name has to be included in that code of statute. And this is one of the main reasons why they're always trying to get people to agree to being one of these, like a U.S. citizen or anything, any of the names and groups that they create, they want people to try to become part of them that way because they only have jurisdiction over what it is that they create. Okay. So when they start creating these groups and different names, U.S. citizen and all that fuckery, and you agree to be one of those, then you're under their jurisdiction at that point. And keep in mind, it isn't you that's under their jurisdiction at that point. It's your little monopoly piece. It's gonna be your conduit. Your commercial conduit is gonna be subject to all their fuckery. It isn't the live, living, breathing version of you that's subject to any of their shit. It's your little monopoly piece essentially that's going to be subject to their shit, and you acting as the administrator for that particular piece are going to have to be the one that rectifies any situations moving forward that pertain to your particular conduit, and that's how that works. But it's never you that they had the jurisdiction over; it's only the piece of paper. All right, keep that in mind. So the attorneys cannot represent any private citizen nor any business, as the state cannot license the practice of law. All right, so keep that in mind too. And so when they're out here acting like they have a license to practice law, I want you to remember one thing. So the word license is only something that people have to get in order to do something that would be illegal otherwise. So when they talk about a driver's license and all that shit, you really don't need it. A license is only for interstate commercial use. The only way that you need that. All right. So if they're talking about a license to practice law, that word alone right there should tell you that they're operating in commerce, because you don't need a fucking license if you're not operating in commerce. Really that simple. So and so that's another thing to bring to their fucking attention too, when you try to get to the bottom of the cause and nature of any of these actions, and they want to pretend that this shit somehow has something to do with law. Well, if that's the case, you wouldn't need a fucking license now, would you? The fuck out of here. So the assertion of federal rights, when plainly and reasonably made, is not to be defeated under the name of local practice. The right The right to travel is a part of the liberty on which citizens cannot be deprived without due process of law under the Fifth Amendment. All right, so there it is. Any lawyer worth his salt will tell the suspect in no uncertain terms to make no statement to police under any circumstances, and that's because anything you say and do will and can be used against you. One of the Fifth Amendment basic functions is to protect the innocent. Under a court lacking jurisdiction cannot render judgment but must dismiss the cause at any stage of the proceedings in which it becomes apparent that the jurisdiction is lacking. The Congress cannot invoke the sovereign power of the people to override their will as thus declared. uh, the same person may be at the same time a citizen of the United States and a citizen of a state, but his right of citizenship under one of these governments will be different from those he has under another. Uh, the jury has the power to bring a verdict in the teeth of both law and fact. 30. So there is no such thing as a power of inherent sovereignty in the government of the United States. It is a government of delegated supreme powers, supreme within its prescribed sphere, but powerless outside of it. In this country, sovereignty resides in the people, and Congress can exercise no power which they have not, but but their constitution entrusted into it, all else withheld. All right, now let me write this down. All right, where we at? So we have recognized in the past, however, that the liberal rules of notice pleading under the federal rules of procedure only require a plaintiff to plead the facts underlying their claim, not the statute itself. Um, to plead to the facts, yeah. So I don't know. I wouldn't recommend pleading the shit. So waivers of constitutional rights not only must be voluntary, but must be knowing. Intelligent acts done with sufficient awareness of the relevant circumstances and likely consequences. Uh, yeah, so they can never ask you to just go ahead and waive your rights. So you should always retain your rights throughout all this fucking nonsense whenever you're dealing with these people. Reservation of rights. As the court's opinion clearly acknowledges, there can be no doubt that the jury has an unreviewable and unreversible power to acquit in disregard of the instructions on the law given by the trial judge. All right, so jury lawlessness Jury lawlessness is the greatest corrective of law in its actual administration. The will of the state at large imposed on a reluctant community, the will of a majority imposed on a vigorous and determined minority. Find the same obstacles in the local jury that formerly confronted kings and ministers. Pound comments that the law as written and invoked by prosecutors demands conviction of person whom local or even general opinion does not desire to punish, and adds that the law is often too mechanical to the point requiring nicety of adjustment. So what they're saying is that, I mean, the country that we live in is really a fucking republic. It just and I mean every country is, to be honest with you, and you can find it in most of the names anyway. And so they always try to push this whole concept of democracy and shit like that on people. And what they're saying is that when you engage in a government such as the democratic government, what you're doing essentially is giving the power of the people who have the majority of people on their side to make the rules for the people who have less people on their side. And so essentially, because they're going to have more votes, then they're going to be able to vote in something that's going to be detrimental to the people who have less votes, essentially, or something like that along those lines. But I mean, you can just tell in the numbers that that shit is not fair, because I mean, everybody has the right to call their own shots in their lives, regardless of who the fuck feels what, for real. So the page of history shines on instances of the jury's exercise of its prerogative to disregard uncontrived evidence and instructions by the judge. So what they're saying here is like regardless of what the judge tells the jury that they can and can't do, they can if they find that something is not right with the whole case, that they can just throw the whole shit out. So while this court has not attempted to define with exactness the liberty thus guaranteed, the term has received much consideration, and some of the included things have been definitely stated. Without doubt, it denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, establish a home, and bring up children, to worship a God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized as common law as essential to the orderly pursuit of happiness by free men. So the framers of the Constitution recognized the distinction between the Republican and Democratic form of government and carefully avoided the latter, right? So that's what I was just telling you. And it's for a fucking reason. So allegiance and protection by the government from harm are, in this connection, reciprocal obligations. One is the compensation for the other. Allegiance for protection and protection for allegiance, right? So essentially, you need to be saved, so, and they're always creating a boogeyman. So you give up your rights for more safety, and it only costs you your freedom. And so that's how that works, right? So the right to protect persons having a domicile, though not native born or naturalized citizens, rest upon the firm foundation of justice, and the claim to be protected is earned by considerations which the protecting powers is not at liberty to disregard. Such domiciled citizen pays the same price for his protection as native born or naturalized pay for theirs. He is under the bonds of allegiance for the country of his residence, and if he breaks them, incurs the same penalties. He owes the same obedience to the civil laws. His property is, in the same way and to the same extent as theirs, liable to contribute to the support of the government. In nearly all respects, his and her conditions as to the duties and burdens of government are undistinguishable. Thus, the court has frequently held that domicile of residence, more substantial than the mere presence of transit or sojourn, is an adequate basis for taxation, including income, property, and death taxes, since the 14th Amendment make one a citizen of the state wherein he resides, wherein he resides, where the hell that go? The fact of residence creates universal reciprocal duties of protection by the state and allegiance and support by the citizen. The latter obviously includes a duty to pay taxes, and their nature and measure is largely a political matter. Of course, the situs of property may tax it regardless of the citizenship, domicile, or residence of the owner, the most obvious illustration being a tax on realty laid by the state in which the realty is located. The citizen cannot complain about the law or tax system because he has voluntarily submitted himself to such a form of government. He owes allegiance to the two departments, so to speak, and within their respective spheres, must pay penalties with each exacts for disobedience of its laws. In return, can demand protection from each state within its own jurisdiction. Now, keep in mind, I mean, we do all this private banking shit, and it's not for nothing. So, and you know that in the IRS employee handbook, it tells you that they accept registered bills of exchange as payment for taxes. So I don't understand why any of you motherfuckers are not paying your taxes when it's really as simple as just registering your fucking security. Everybody who already did their UCC ones and three, you already know what time it is. You can just register your security via UCC three partial assignment of interest, and then go ahead and send it into the address that's right in the employee handbook manual. In accordance with ancient principles for the international law of nation states, the court in the Chinese exclusion case held broadly, as the government describes, briefs for its appellants. The power to exclude aliens is inherent, as the government describes it before appellants, uh, in sovereignty necessary for maintaining normal international relations and defending the country against foreign encroachments and danger. A power to be exercised exclusively by the political branches of government. Since that time, the court's general reaffirmations of this principle have been legion. The court, without exception, has sustained Congress plenary powers to make rules for the admission of aliens and to exclude those who possess those characteristics which Congress has forbidden, which would be like a criminal record and shit like that. So the governments are but trustees. The governments are but and so this is case law. The governments are but trustees acting under derived authority and have no power to delegate what is not delegated to them. But the people, as the original fountain, may take away what they have delegated and entrust to whom they please. The sovereignty in every state resides in the people of that state, and they may alter and change their form of government at their own pleasure. Now, this is the reason why the Second Amendment is so fucking important. It has nothing to do with hunting or any of that fuck shit. It's so that way these people know that at any point we get sick of their bullshit, the people having the power to change their government just might fucking do so. Real simple. So while sovereign powers are delegated to the government, sovereignty itself remains with the people. All right. So this is right here case law to back that up. If they want to act stupid about you calling yourself sovereign, it's already been ruled on fucking numerous cases that the people are sovereign. So if anybody has a problem with the word, they should go get a fucking dictionary and go find God, bro. Go fucking find him. The right to speak and the right to refrain from speaking are complementary components of the broader concept of individual freedom of mind. At the heart of the First Amendment is the notion that the individual should be free to believe as he will. And in that, a free society of one belief should be shaped by his mind and his conscience rather than coerced by the state, right? The power of exclusion of foreigners being an incident of sovereignty belonging to the government of the United States as a part of those sovereign powers delegated by the Constitution, the right to its exercise at any time in the judgment of the government, the interest of the country require it, cannot be granted away or restrained on behalf of anyone. The power of government are delegated in trust to the United States and are incapable of transfer to any other parties. They cannot be abandoned or surrendered, nor can their existence be hampered when needed for the public good. By any considerations of private interest, the exercise of these public trusts is not the subject of barter or contract. Now, what I find funny is that all of these states, when it says it right here explicitly in a fucking ruling, that the states are not allowed to delegate the authority that was given to them by the people to any other corporations, and then you see these fucking states or companies or corporations, whatever you want to call them, doing business with like the Federal Reserve and shit like that and taking money from those people, essentially becoming a fucking subjugated, right? So they're going to become subject to the people that they're taking loans from and taking fake fucking monopoly money from. And so now they got to listen to them because now they're in a contract with them. Essentially, what they did was violate this ruling right here, which says that they're not allowed to delegate that to anyone else. When in all reality, they're making everybody subject to the people that they're borrowing money from. It's something to think about. So the word people of the United States and citizens are synonymous terms and mean the same thing. When they both describe the political body, according to our Republican institutions, form the sovereignty, and who hold the power and conduct the government through their representatives. They are what we familiarly call the sovereign people, and every citizen is one of these people and a constituent member of his sovereignty. In order to be a citizen of the state within the meaning of the diversity statute, a natural person must both be a citizen of the United States and be domiciled within the state. And then here we got the case law to support that as well. So the problem in this case is that Bedison, although a United States citizen, has no domicile in any state. He is therefore stateless for purpose of clause whatever this is here. And what else did it say? Yeah, just that they could not find the state citizenship of that person there. So citizenship is a political tie. Allegiance is a territorial tenor. The doctrine is that allegiance cannot be due to two sovereigns, and taking an oath of allegiance to a new is the strongest evidence of withdrawing allegiance from his previous sovereign. The right of domicile, he continues, is not established unless the person makes sufficiently known his intention of fixing there, either tacitly or by an express declaration. Okay. So, since the 14th Amendment makes one a citizen of the state wherein he resides, the fact of resident creates universally reciprocal duties of protection by the state and of allegiance and support by the citizen. The latter obviously includes a duty to pay taxes, and their nature and measure is largely a political matter. From the difference existing between feudal sovereignties and government founded on compacts, it necessarily follows that their respective prerogatives must differ. Sovereignty is the right to govern a nation, or state sovereign is the person or persons in whom that resides. In Europe, the sovereignty is generally ascribed to the prince. Here it rests with the people. There, the sovereign actually administers the government. Here, never in a single instance, our governors are the agents of the people and at most stand in the same relation to their sovereign in which regents in Europe stand to their sovereigns. Uh, their princes have personal powers, dignities, and preeminences. Our ruler have none but official, nor do they partake in the sovereignty otherwise in any other capacity than as a private citizen. So there's basically right there it's telling you that the governor here really has no more power than you or I would, but they sure play a different game though, don't they? I'm not the one that makes these rules up, man. I'm just reading them to you. So, the makers of the Constitution undertook to secure conditions favorable to the pursuit of happiness. They recognized the significance of man's spiritual nature, of his feelings, and of his intellect. They knew, they knew that only a part of the pain, pleasure, and satisfactions of life are to be found in material things. They sought to protect Americans in their beliefs through thoughts, their emotions, and their sensations. They conferred they conferred as again the government the right to be left alone, the most comprehensive of rights and the most valued by civilized men. And we all have the rights to be left alone. But it sure doesn't feel like that when you're out there driving around and these motherfucking pirates always fucking pulling people over and harassing them. That sure don't feel like privacy to me at all. And it's just a shame that they call themselves fucking enforcement of law when they don't even know what the fucking law is. That shit is just ridiculous to me. For real, it's fucking horrendous. So Congress cannot authorize a trade or business within a state in order to tax it. When a statute includes an explicit definition, we must follow that definition, even if it varies from that term's ordinary meaning. And this is why you always want to ask them which dictionary that they're using when you're trying to figure out what the fuck it is that they're talking about. Because they go ahead and hand us Webster's dictionary, and then they start creating codes and statutes based on Black's Law Dictionary. That's a little ridiculous. And if I got to say, I'm pretty sure it was done purposely. Okay. So If the time shall ever arrive when for an object appealing however strongly to our sympathies, the dignity of the states shall bow to the dictation of Congress by conforming their legislation thereto. When the power and majesty and honor of those who of those who created shall become subordinate to the thing of their creation. So what this is saying is that when these people start making laws and shit, that they're going to be bound by all that shit too, just as well as you are. And keep in mind that they can only make rules, codes, and statutes for themselves. They don't have the authority to start making power for private people. It's just not there. So I but feebly utter my apprehensions when I express my firm conviction that we shall see the beginning of the end. In addition to this, however, the United States are not one of the class and corporations intended by law to be exempt from taxation. So this right here says that the United States is not exempt from taxation. So it is a corporation that is taxable, okay? So what the corporations are to which the exemption was intended to apply are indicated by the tax laws of New York and are confined to those of a religious, educational, charitable, or reformatory purpose. So we think it was not intended to apply it to a purely political or governmental corporation like the United States. All right. So that right there makes it pretty clear if you're trying to make a case for the fact that the United States is a corporation and is taxable. And there it is. All right. So indeed, the practical interpretation put by Congress upon the Constitution has been long continued uniform to the effect that the Constitution is applicable to territories acquired by the purchase or conquest only when and so as far as Congress shall so direct, notwithstanding its duty to guarantee every state in this Union a Republican form of government, by which we understand, according to the definition of Webster's, a government in which the supreme power resides in the whole body of the people, all right, and is exercised by the representatives elected by them. Congress did not hesitate in the original organization of the territories of Louisiana, Florida, the Northwest Territory, and subdivisions of Ohio, Indiana, Michigan, Illinois, and Wisconsin, and still more recently in the case of Alaska, to establish a form of government bearing a greater analogy to the British Crown Colony than a Republican state of America, and to vest the legislative power either in a governor and council or a governor and judges to be appointed by the president. It was not until they had attained a certain population that the power was given to them to organize a legislature by vote of the people. In all these cases, as well as in territories subsequently organized west of Mississippi, Congress thought it necessary either to extend the Constitution and laws of the United States over them, or to declare the inhabitants should be entitled to enjoy the right of trial by jury, of bail, and privilege of writ of habeas corpus, as well as the other privileges of the Bill of Rights. All right. Now, keep in mind, one of the main reasons why you would be trying to prove in court that not only are they subject to the U.S. code and statutes, the fact that they are a corporation is going to be made clear to everybody for the reason of you using consumer law and 15 USC cease and desist in order to send these motherfuckers to hell. You know what I'm saying? So it's really, I mean, it's really just a matter of that. And so I also have lists of all of the DUNS numbers, which are the registered business numbers for every single state, every single organization, every single supposed government entity that operates in the United States, and they all got registered business numbers, which means that they're publicly offered companies that in fact do have shareholders as well. Okay, so they're for-profit companies. Keep that in mind. So what else do we got here? Let's see what we got. Hang on, let me write this time down. Wow, we're already at 44 minutes. That's crazy. 44 minutes. So legislature can be invoked. All right, we're gonna leave that. So there is a clear distinction in this particular case between an individual and a corporation, and that the latter has no right to refuse to submit its books and papers for examination at the suit of the state. The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no such duty to the state since he receives nothing therefrom, beyond the protection of his life and property. His rights, his rights are such as existed uh, by the law of the land and long antecedents to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. Among his rights are the refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a warrant of law. He owes nothing to the public so long as he does not trespass upon their rights. Okay. So our system of taxation is based upon voluntary assessment and payment, not distraint. All right. So you got case law right here that backs that up. All right. I'll say it one more time. Our system of taxation is based upon voluntary assessment and payment, not distraint, meaning that they can't send you any fucking threatening letters, threaten to fucking lien your house, threaten to fucking levy your paychecks and shit like that. Absolutely not. All right. So a tax in the general understanding of the term and as used in the Constitution signifies an exactation for the support of the government. The word has never thought to connote and to connote the expropriation of money from one group for the benefit of another. So right here you have these two case law right here to back up the fact. If you ever end up in court for taxes, it says it right here that these cases have already been ruled on. Okay. And so a reasonable construction of the taxing statutes does not include vesting any tax official with an absolute power of assessment against individuals not specified in in the statutes as a person liable for the tax without an opportunity for judicial review of his status before the appellation of a taxpayer is bestowed upon them and their property is seized. The distinction between and keep in mind that it doesn't matter even if you want to call your little monopoly piece of taxpayer, you should just know how to create instruments because there is no money in this whole system. We're all out here playing with fucking monopoly money, and they do have an obligation to fucking accept your bills of exchange. All right, they do have an obligation to. S- The distinction between parties and things within the scope of the revenue laws and those without is vital. It is no longer open to question that the general government, unlike the states, possess no inherent power in respect to the internal affairs of the states, and emphatically not with regard to legislation. The difficulty arising out of our dual form of government and the opportunities for differing opinions concerning the relative rights of the state and national governments are many, but for a very long time this court has steadfastly adhered to the doctrine that the taxing powers of Congress do not extend to the states or their political subdivisions. The same basic reasoning which leads to the conclusion we think requires limitation upon the power which brings the bankruptcy clause. Congress cannot authorize a trade or business within a state in order to tax it. The government of the United States has been emphatically termed a government of laws and not men. It will certainly cease to deserve that high appellation if the law furnished no remedy for the violation of vested legal right. The power to create presumptions is not a means of escape from constitutional restrictions. And this is the thing, too, presumptions. So they have all these police officers out here dressed in costumes, 100% fucking brainwashed under the presumption that what the fuck that they're doing is 100% legit. Now, mind you, they're only doing that because none of them have studied law and none of them have looked any further than their boss's fucking paper that they handed them when they told them to go out and do this today. All right. So the provisions of the 16th Amendment conferred no new power of taxation. It has been well said that the property, which every man has his own labor, as is the original foundation of all other property, so it is most sacred and inviolable, meaning that it cannot be violated. The patrimony of the poor man lies in the strength and dexterity of his own hands, and to hinder his employing this strength and dexterity in what manner he thinks proper, without injury to his neighbor, is a plain violation of his most sacred property. Mhm. Included in the right of personal liberty and the right of private property, partaking in the nature of each, is the right to make contracts for the acquisition of property. Chief among such contracts is that of a personal employment, which by labor and other services are exchanged for money and other forms of property. Every man has a natural right to the fruits of his own labor, is generally admitted, and no other person can rightfully deprive him of those fruits and appropriate them against his will. And so that's a good argument for this fucking taxation as well. So the power to legislate generally upon life, liberty, and property, as opposed to the power to provide modes of redress against offensive state action, was repugnant to the Constitution. So let's write this down. Damn, bro, we're almost at a fucking hour already. That's crazy. Don't worry, we got two more pages. So at the revolution, the sovereignty devolved on the people. They have are truly the sovereigns of the country, but they are sovereigns without subjects, with none to govern them but themselves. The citizens of America are equal as fellow citizens and as joint tenants of in this sovereignty. So that pretty much clears it up right there, right? So the very meaning of sovereignty is that the decree of the sovereign law of the sovereign makes the law. So pretty much it says that whatever you say is the law, basically. So it will be an evil day for American liberty if the theory of a government outside of the supreme law of the land finds lodgment in our constitutional jurisprudence. No higher duty rests upon this court than to exert its full authority to prevent all violation of these principles of the Constitution. To presume that a sovereign forever waives the right to exercise one of his powers unless it is expressly reserves the right to exercise that power in a commercial agreement turns the concept of sovereignty on its head. So the jury's options are by no means limited by the choices presented to it in the courtroom. Keep that in mind. So even when an ordinance requires a permit to make such a speech, to deliver a sermon, to picket or to parade or to assemble, it need not be honored when it is invalid on its face. Basically saying that when these people tell you to do shit that you know is not right or is contrary to the Constitution, then fuck them. So these examples and many other demonstrate an alarming trend whereby the privacy and dignity of our citizens is being withheld away by sometimes imperceptible steps taken individually. Each step um, may be of little consequence, but when viewed as a whole, there begins to emerge a society quite unlike any we have seen, a society in which government may intrude into the secret regions of a man's life at will. And you know, all of our fucking devices are all tapped and shit. You know what I mean? You already know that. I mean, they're listening through every device, fucking through every camera they're looking through. Count on it. All right. So it is better. So the Fourth Amendment teaches that the guilty sometimes go free than that the citizens be subject to an easy arrest. And that's a fact. You know, they're out here picking on the weak links, to be honest with you, essentially. I cannot assent to that view if it be meant that the legislature may impair or abridge the rights of a free press and of free speech whenever it thinks that the public welfare requires that that be done. The public welfare cannot override constitutional privileges, and if the right of free speech and of a free press are in the essence attributes of natural citizenship, as I think they are, then neither Congress nor any state since the adoption of the 14th Amendment can by legislation um, can by legislative enactments or by judicial action impair or abridge them. So basically, they're saying that nobody can tell you to shut up if you got something to say, right? Because they feel that it's for the betterment of everybody else for you not to speak on it. Yeah, okay. So, but in the view of the Constitution, in the eye of the law, there is in this country no superior dominant ruling class of citizen. There is no castle here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. The law regards man as man and takes no account of his surroundings or of his color when his civil rights are guaranteed by the supreme law of the land are involved. But if there is any principle of the Constitution that more imperatively calls for attachment than any other. It is the principle of free thought, not free thought for those who agree with us, but freedom for the thought that we hate. The liberty of the press is not confined to newspapers or periodicals. It necessarily embraces pamphlets and leaflets. These indeed have been historic weapons in the defense of liberty, as the pamphlets of Thomas Paine and others in our own history abundantly attest. The very purpose of a Bill of Rights was to withdraw certain subjects from the vicissitudes of political controversy. One's right to life, liberty, and property, to free speech, a free press, freedom of worship and assembly may not be submitted to vote. They depend on no elections. The claim and exercise of constitutional right cannot thus be converted into a crime. All right. So when you're exercising any of your rights, which you already know what they are, none of them can be converted into a crime in the sense that they cannot charge you criminally with any of those. On top of the fact that nobody's been violated in any of that shit either. So you already see what that is. All right. So the opinion of the Federalist has always been considered as a great authority. It is a complete commentary on our Constitution and is appealed to by all parties in the question to which that instrument has given birth. Its intrinsic merit entitles into this high rank. So the main thing right here, you guys need to get on your Bill of Rights. Definitely look at those. Those are going to be crucial in any cases that you're dealing with. If you need this PDF right here, so you can use this case law to enter into any of your cases in order to get them shits thrown out or to back up whatever it is that you're trying to get done, send me an email. I'll send it right over to you. You already know it's a game of chess. Stop playing checkers with these clowns. That's what I got for you for now. Until we meet again.